For coming. We're really excited for this event. My name is Alicia Landis, and I am the co-chair for both American Constitution Society and Women's Law Caucus. We, along with the Government Law Society, are so excited to be hosting this event for you. As many of you know, this year marks the 100th anniversary of the ratification of the 19th Amendment. We thought it was super important to have an event honoring this anniversary and to highlight the challenges that still lie ahead. We've prepared a few questions for the panelists, and we'll try to save time at the end for audience questions. I will be first introducing our moderator, Assistant Professor of Law, Ciji Dodds. Professor Dodds received her BA from the University of North Carolina at Chapel Hill and her JD from Howard University School of Law. Professor Dodds currently teaches Introduction to Lawyering at Albany Law School. She came to Albany Law in April 2019 after 5 years on the faculty of the University of the District of Columbia David A. Clark School of Law, where she taught courses in the legal writing and academic success programs. Her research and teaching interests include clinical instruction, legal writing, property, critical legal studies, and critical race theory. As principal of the Dodds firm in Washington, D.C., Professor Dodds represents startups, nonprofits, and small businesses in corporate and real estate transactions. She also provides civil litigation services for members of marginalized communities. Previously, she was an associate at Kelly Dry & Warren LLP and Wambley, Carlisle, Sandridge & Rice LLP, and an assistant attorney general, all in Washington, D.C. Professor Dodds' volunteer efforts reflect her commitment to helping the underserved and supporting girls and young women. She has worked as a pro bono attorney for the U.S. Committee for Refugees and Immigrants and served on the board of directors of AYA Inc., a mentoring organization for young women of color. She also was a coach for Girls on the Run DC, a nonprofit that helps girls develop life skills and an appreciation for health and fitness. And with that, I'll turn it over to Professor Dodds. Thank you.
Hi, thank you, and good evening to everyone. I'm so excited to be here. I will begin by introducing our panelists. After that, we have some questions that we'll go through with our panelists. And as we are speaking, if you have questions that you would like to ask them, please type them, and I will be pulling from the chat function and giving those questions for them to answer at the end of our program. Okay, so I would like to begin with Judge Stein. Judge Leslie E. Stein, Associate Judge of the Court of Appeals, received her BA Phi Beta Kappa from Macalester College and her JD Magna Cum Laude from Albany Law School. Judge Stein began her legal career as the law clerk to the Schenectady County Family Court judges. She then became associated with the Albany law firm of McNamee, Lochner, Titus, and Williams, PC, where she practiced matrimonial and family law and became a partner in the firm. While a practicing attorney, Judge Stein was elected a Fellow of the American Academy of Matrimonial Lawyers. She began her judicial career as an Albany City Court judge and acting Albany County Family Court judge. She was then elected to the New York State Supreme Court, 3rd Judicial District for a term commencing January 2002. She served as the administrative judge of the Rensselaer County Integrated Domestic Violence Section from January 2006 until February 2008, when she was appointed a justice of the New York State Appellate Division, 3rd Department. In October 2014, Judge Stein was nominated by Governor Andrew Cuomo to serve as an associate judge of the Court of Appeals, and her nomination was confirmed by the New York State Senate on February 9, 2015. Judge Stein is a past co-chair of the New York State Unified Court System Family Violence Task Force. She was a founding member of the New York State Judicial Institute on Professionalism in the Law and chaired the 3rd Judicial District Gender Fairness Committee from 2001 to 2005. She also served on the Executive Committee of the Association of Justices of the Supreme Court of the State of New York and as an officer of the New York State Association of City Court Judges. Judge Stein has lectured and developed curricula for continuing legal education of attorneys and judges on multiple topics. She has a long history of involvement in various state and local bar associations and in a number of other professional and civic organizations. Let's welcome Judge Stein. Okay, next we have Judge Riva. The Honorable Judge Christina L. Riva was elected in 2015 by the people in the 3rd Judicial District to serve as the Justice of the Supreme Court of New York. Prior to beginning her term in 2016, she held various positions in the court system for the Office of the Court Administration and in the New York State Supreme Court Third Department Appellate Division, including Special Projects Counsel to the Deputy Chief Administrative Judge for the courts outside New York City and Special Projects Counsel to the Presiding Justice of the Appellate Division Third Department. Prior to her work with the judiciary, she was an associate at Nixon Peabody. She also served as an Assistant Attorney General for the State of New York Litigation Bureau. Additional public service includes an appointment first as General Counsel and then as Deputy Director of the City of Albany Community Development Agency. She is a past president of Albany Law's National Alumni Association and past president of the Albany County Bar Association. She received her undergraduate degree from Skidmore College, cum laude. Everyone, let's welcome Judge Riva. Next, we have Professor Mary Lynch. Professor Lynch is the Kate Stoneman Chair in Law and Democracy, a magna cum laude graduate of NYU and a cum laude graduate of Harvard Law School. She served as an assistant district attorney in the New York County from 1985 to 1989. She joined the Albany Law School faculty in 1989 and for the past 20 years has directed the Domestic Violence Prosecution Hybrid Clinic. During her tenure at Albany Law, she taught and directed the Disabilities Law Clinic, the Field Placement Clinic, and the Post-Conviction Remedies Clinic. In 1997, while serving as director of Albany Law's Domestic Violence Law Project, she and 7 Albany Law School students won a groundbreaking clemency case for an incarcerated battered woman who killed her abuser. The range of courses she has taught includes criminal procedure adjudication, disabilities law seminar, domestic violence law seminar, pretrial and trial practice courses, both civil and criminal, and litigation planning and skills. Her scholarship has focused on multicultural awareness in legal education and law practice, gender bias, violence against women, and legal education reform. From 2001 to 2009, Professor Lynch directed or co-directed the Albany Law Clinic and Justice Center. Albany Law School has honored her with the Excellence in Teaching Award in 2014 and the Kate Stoneman Special Recognition Award for contributions to the advancement of women in the legal profession. Professor Lynch has played a leadership role in the movement to modernize legal education. From 2007 to 2020, she served as the editor and frequent contributor of the award-winning Best Practices for Legal Education blog, and from 2009 to 2020 as the director of the Center for Excellence in Teaching at Albany Law School. Nationally, she has served as co-president and on the board of the Clinical Legal Education Association, which is an organization with over 1,200 members, and as an executive committee and board member of the American Association of Law Schools section on clinical legal education. She has been honored by NOW's Capital Region Division with the Making Waves Award, and as an Irish Legal 100 honoree by the Irish Voice, and as a top 100 Irish American by Irish America magazine. Let's all welcome Professor Lynch. Okay. And up next, we have Professor Ava Ayers. Professor Ayers received her BA from Vassar College and her JD from Georgetown Law. Professor Ayers graduated first in her class from Georgetown Law in 2005. She then clerked for the Honorable Sonia Sotomayor, now a U.S. Supreme Court Justice, during her term on the U.S. Court of Appeals for the Second Circuit. She also clerked for the Honorable Gerard Lynch on the U.S. District Court for the Southern District of New York. After clerking, Professor Ayers worked for 9 years in the Office of the New York Attorney General, where she was a Senior Assistant Solicitor General. She served both as a supervisor and lead counsel in various high-profile cases involving immigration law, states' rights, constitutional rights, environmental law, and other issues. Professor Ayers is the author of A Student's Guide to Law School, published by the University of Chicago Press, as well as articles on legal ethics, immigration law, federalism, and other subjects. Professor Ayers is currently the director of the Government Law Center at Albany Law School. Let's all welcome Professor Ayers. Okay, So thank you, everyone. I'm really excited to get started. We have some great questions. As a reminder, as our panelists are discussing or giving their answers to the questions, if your questions pop up, please type them up into the chat box and we will get to them towards the end of the program. Now, our first question, and this is for anyone who wants to jump right in there, is as we commemorate the 100th anniversary of the 19th Amendment, do you believe it assured the right to vote for all women in the United States?
I'd like to start with answering that question if I could. So first, thanks for including me in this very important forum. From a review of history, it's clear that the 19th Amendment did not assure the right to vote for all women in the United States. For some context, let's think about where this country was in the 1920s. In 1924, the Johnson-Reed Act was signed by President Hoover. It was a federal law that prevented immigration from Asia. It set quotas on the number of immigrants from the Eastern Hemisphere and provided ways to carry out a long-standing ban on other immigrants. In the 1920s, the Ku Klux Klan was an active group that terrorized Black people with, among other things, lynching and cross burnings. It was 45 more years before the Voting Rights Act of 1965 was passed to overcome legal barriers that prevented Black people from exercising their right to vote as guaranteed under the 15th Amendment to the Constitution. And as quick background, the 15th Amendment was ratified in 1870 and was supposed to prohibit the federal government and the state from denying a citizen the right to vote based on the citizen's race, color, or previous condition of servitude. 2 years later, prior to the 15th Amendment, or 2 years prior, the 14th Amendment was adopted, which, among other things, dealt with citizenship rights and other issues faced by former slaves. So it's no surprise that the mainstream suffrage movement endured racially discriminatory practices along with the rest of America. And from my research, it's apparent that the suffrage movement even condoned white supremacist principles in order to gather Southern support for white women's voting rights. And consequently, African-American women and men became increasingly marginalized and discriminated against at women's suffrage meetings, at campaigns and marches. Research shows that Susan B. Anthony and other white suffragists in the South and the North continue to focus on their immediate needs over loyalty and justice for Black suffragists. An example of this discrimination is in 1895, Susan B. Anthony asked her friend Frederick Douglass not to attend an upcoming women's suffrage convention in Atlanta, as she later explained to Ida B. Wells Barnett, a prominent leader in the civil rights movement and one of the founders of the National Association for the Advancement of Colored People, otherwise known as the NAACP, quote, Douglass's presence on the stage with the honored guest would have offended the Southern hosts. So after this incident, apparently, Wells Barnett and other suffragists reprimanded Anthony, along with other white women activists, for giving in to racial prejudice. Notably, there were exceptions to the discriminatory traditions among suffragists. Some African-American women, such as internationally prominent women's rights activist and speaker Mary Church Terrell, belonged to and participated in women's suffrage meetings. And even though she faced discrimination, as a result of mistreatment and discrimination, Black women formed their own local and regional women's suffrage clubs. And in 1896, the National Association of Colored Women, known as the NACW, was formed. This provided Black women a national platform to advocate for women's suffrage and women's rights causes. Despite experiencing discrimination, research shows that Black women joined efforts to secure the ballot for women and to expand women's engagement in electoral politics as canvassers, organizers, and voters. In 1913, Ida B. Wells Barnett organized the first Black women's suffrage club in Illinois. And even though Black women were often overlooked in the history of the women's suffrage, they engaged in significant reform efforts and political activism leading to and after the 19th Amendment in 1920. Following ratification of the 19th Amendment, the battle for voting rights ended for white women, but for Black women, the outcome was less clear. So in summary, post-1920, there was a lot more work that needed to be done to ensure fair voting opportunities for Black women and men, for that matter. It would be 4.5 decades after the 19th Amendment when Black people would see more voter protections. The Civil Rights Act of 1964 had a great impact on people of color, and the Voting Rights of 1965 prohibited racial discrimination in voting. It was signed by President Lyndon B. Johnson in the height of the Civil Rights Movement, and it was designed to enforce the voting rights guaranteed by the 14th Amendment and the 15th Amendment to the US Constitution. So I guess in 2065, we can celebrate the 100th anniversary of the Voting Rights Act of 1965, which was pivotal in ensuring Black citizens the right to vote in North America.
Thank you. That was amazing to hear. And sometimes we forget just how short a time ago we didn't have the rights that we have right now. Would anyone else like to add on to that?
Well, I think what Judge Riba's historical perspective really points out to us is that the legal or constitutional right to vote does not necessarily equate to the practical right or ability to vote. And even and beyond that, the right or ability to vote for what one's positions really are. For example, I think about how, aside from voter suppression generally, which we well know is still a problem and very active and very problematic today, not just in terms of women, but beyond that. I think about how long it took women to actually get the legal right to vote and what the circumstances were like in the 1920s when they finally did get that legal right. And how for many years, and perhaps even still today in some circumstances, women generally voted however their husbands told them to vote. And many women were not educated in politics, and you know, that was kind of the way things were. Today, I think that more and more women do vote. I think that the numbers of women in elective office has grown. Perhaps I think during this program we'll talk some about women in the legal profession, which also still has some really serious limitations on advancement. But you know, the saying, "We've come a long way, baby," we still do. You know, you hear it all the time, but it is absolutely true. We still have a long way to go, although I think that in some areas it's improving, while in others maybe it's not as improving as much.
Thank you, Judge Stein. Professor Lynch, I see you.
Unmuting myself, yeah. So I really think this is, you know, such a provocative question. And I think it's relevant not just to activists of the 19th century, but activists of the 21st century. What does it mean to be part of a mission that wants to be inclusive or non-biased on a particular identity characteristic like gender? And is there something that we now import about whether it's a feminist way of thinking or it is an inclusive way of thinking that expects a kind of intersectionality that frankly the law doesn't really embrace, right? The law is about different strands of each thing. This idea of an intersectional sort of holistic approach to looking at not just what is de jure, but what is de facto. It has been it is an effort that I think is an ongoing effort, not only of some folks on this call, but also of the next generation. When I think of suffrage, given my title here at Albany Law and my adoration of Kate Stoneman, I try to picture, you know, when you think about it, she was born in 1841, and our law school was founded 10 years later. She was about 7 years old when the suffrage movement, as we know it from the 19th century, was really active in Western New York. So this was a place where suffrage occurred. There were times when it overlapped with abolitionism. And there were times when, exactly as Judge Ryba said, different factions within the organization and at different levels, compromises were made that betrayed, in some ways, the very people who at first coalesced together. And so there is a lot of pain in this story. There is a lot of fraction, but then there's also so much happening that in history, you need to look at different strands. So one piece I'm just going to read about is, in New York in 1917, the New York State Constitution granted women the right to vote. But before that, there was a vote on school boards, right, that was given in New York. And why were women allowed to vote on that? Well, because women, right, there's all this gender stuff imputed into women. And so women will let them edge where there's caretaking. And in response to this right to vote, Kate Stoneman started the Albany Women's Suffrage Society. And there were different societies in Albany on suffrage. Some of them were racist. Some of them were more inclusive. Now, in a history that Kate wrote, so, she's writing her own history here. I wasn't there at the time. I can't talk about all of it. But so far, Kate, we remember, for those of you who are first years, Kate Stoneman is the first woman admitted to New York State Bar. She changed the law for New York. And it was very interesting that the statute that she did precluded you making gender or race a bar to admission to the New York State Bar. So the thoughts of this suffrage society, that the suffrage set out to register to vote, and most were successful, but in some wards, women were refused. So like these are the Albany wards. Among those who registered were Dr. Mary Dubois, and this is the leading female position, and 6 Black women, led by Mrs. C. Mary Williams, a vice president of the County Women's Suffrage Society, and a woman of, quote, considerable education and refinement. Despite intimidation, verbal abuse, and threats of violence, 25 to 30 women voted in Albany's charter election on April 13th, 1880. This was on the school board. Our Kate Stoneman was at the polls before they opened and was the first person to vote. So she clearly was an eager beaver when it came to voting. And 2 other points I would want to make. I think that when we think about women and suffrage, not only should we think about intersectionality, but I also think we should think about the practical effects of voting suppression. We know that the large majority of childcare in this country is done by women. We know about the large number of single-headed households in this country where you're a mom and you work and you have very little time in between. So when there is geographical voter suppression, like at one point, my daughter was doing vote calling and it turned out Louisville had like 1 polling station. When you're talking about long places, when you're talking about only having voting open from 9 until 6 at night, if you leave work and pick up your child and then have to feed the child who's screaming hungry, when are you supposed to vote? Because in the morning, you're getting the child ready to go to childcare. So I think that the actual effect, the effect on women's actual lives, not their pretend lives that sometimes you find talked about, we have a lot of work still to do.
Thank you, Professor Lynch. Professor Ayers, would you like to add?
I'd love to, thank you. And I just want to say thank you to ACS and the Women's Law Caucus and the Government Law Society for inviting me to be here with these very distinguished co-panelists. It's such a pleasure. And of course, Professor Dodds, it's always a pleasure to be anywhere with you as well. So what I want to focus on, I guess, because I, of course, agree with everything that my co-panelists have said so far, is to talk about how the 19th Amendment was part of a series of events in which you can see how voting is a metaphor for citizenship. There's a great interview with a Black woman studied by somebody who studied by voting rights in the 60s who talked about the sense of somebodyness, that when you vote, you've got that elusive quality of somebodyness. You're becoming a somebody. And there's also a political theorist, Linda Bosniak, who says that citizenship is soft on the inside, but hard on the outside, meaning that anytime we include, we also exclude others. And so throughout the history of voting inclusion, at every stage, you can see who is being excluded and the way that the value of that somebodyness that's being granted to the people who can vote depends to some extent on who exists out there that doesn't have that sense of somebodyness. There are historians of slavery who say that the whole American exceptionalist attachment to the idea of freedom became sort of our national commitment in part because when our identity was being forged as a nation, Americans knew better than anybody else what it meant to not have freedom because we were depriving it of so many people in this country as we were enslaving them. The value of our inclusion has always been dependent on people who are not being included along with us. And so the first great voting rights movement in American history was voting rights for landless people, people who didn't own property. And the value attached to voting depended in significant ways on ideas of freedom that were attached to ideas of slavery, because you had landless people who fought in the revolution who said, I'm a veteran, don't treat me like a slave. The comparisons were very frequent and very explicit in the rhetoric. Don't make me like a slave. Voting and slavery were seen as the opposite sides of each other. And so when women's suffrage became an issue after the 15th Amendment, after Black men had nominally been given the right to vote, although of course Jim Crow laws made sure that that wasn't a reality, many of the leaders of the women's suffrage movement had been at different times in the past abolitionists. And as their movement went forward, what happened was what Ta-Nehisi Coates calls the Great Schism between the abolition movement and the women's suffrage movement. Like they really should have been working together. You know, in retrospect, in history, it looks like they were fighting for the same cause, or at least closely related causes. So what happens? And just as others have said, a choice was made by many leaders in that movement that in order to successfully pass women's suffrage, they needed to use the racial other as ammunition for their argument. And so some of the most vicious racist rhetoric imaginable comes as part of the case for women's rights. There's a quote from a prominent suffragist named Carrie Chapman Catt, who said that thanks to the 15th Amendment, the Black man is sovereign while all white women are their subjects. Right, so because the Black man has the right to vote and white women don't. And so this explicit fear of Black male control over white womanhood, which of course was the precious flower of the South and probably of the whole country, was crucial, as was the understanding that Black women weren't getting the right to vote. That's why it was safe. Thanks to poll taxes and literacy tests, there was no danger that Black women would begin voting after women's suffrage. And that was essential to support for the passage of the amendment. And so as time goes forward, other suffrage movements, in 1924, Native Americans became legally citizens of this country and thus nominally able to exercise the right to vote. Sometime later, as I think it was Judge Ryba who was saying, non-citizens, Asian immigrants, East Asian immigrants, were ineligible to citizenship at the time that the 19th Amendment passed, which meant, of course, that no matter how long they were here, they couldn't vote. And so throughout this process, inclusion has always carried with it exclusion. And I think that looking at, there's always two reasons to give yourself the right to vote. There's two reasons why you might want it. One is that it's symbolically very important. It carries somebodyness. The other one is that, voting is great, but being realistic, it rarely makes a difference, right? We rarely go, I'm not going to decide anybody's election in 2 weeks, even though I am absolutely voting for it. But the hope is that by giving me that status as a voter, I will then be recognized in other ways, that I will enjoy the benefits of full equality in other areas of society. So I think the test of whether the work of the 19th Amendment is done is whether we've achieved women's equality in other areas of society. And until that happens, it can hardly be counted as a successful amendment to the Constitution.
Thank you, Professor Ayers. I know this is probably a challenging question for everyone, but I would just like to reflect on the fact that at this moment in time, a little over at the 100-year anniversary, in 1913, we have the members of the historically Black sorority Delta Sigma Theta who challenged the racism in the women's suffrage movement when they were asked to walk at the back of the suffragist parade on the eve of Woodrow Wilson's inauguration. And now fast forward, and of course they said no. And now fast forward to 2020, where we have Kamala Harris, a member of Alpha Kappa Alpha Sorority Incorporated, who is now the Democratic vice presidential nominee. So we have a long way to go. But like everyone, probably on this call, I'm very proud of how far we have come. So now I would like to go on to my next question, and this one is for anyone as well. What barriers to gender equality do you still see in your capacity as a member of the legal community? I treat you like my students, just jump in.
Supreme Court judge, I preside over, I'm the civil part, so I preside over matrimonials, I preside over personal injury actions, medical malpractice. And what I've noticed is when it comes to litigation and becoming a partner in firms, I see that there's less and less women in those roles. And so I think that I think there should be something done to look at how law firms can be more diverse and create opportunities for women to both succeed at the firm and also balance their other home obligations. And so I just noticed that I also see very little minorities in the civil side of Supreme Court. So I think there's work to be done in private practice, encouraging and promoting women and minorities into to sustaining time at the firm. I think there's associates, but I don't know if they really make it to the partner level. So I think that's something that law firms should be looking at.
So I would answer that from a couple of perspectives. One is that just to indicate where we actually are. Just yesterday, and I get tons of emails about law-related articles from the Law Journal and law.com and all kinds of things. And yesterday there was a glass ceiling report on Law 360, and there were 5 articles, and the headlines were as follows. Number 1, these firms have the most women in equity partnerships. So they have to highlight which firms actually have women in equity partnerships. 2, what big law can do to actually retain female attorneys. 3, female attorneys gain ground in battle for clerkships. 4, wearing natural hair in big law. And 5, mentorship is key to fixing drop-off of women in the law. So that tells you about where things are and how people are still grasping to figure out. Part of it is, I mean, it's not that hard to figure out really what the barriers are, but Professor Ayers talked about where there's inclusion, there's exclusion. And so frankly, to overgeneralize here, those who have been at the top all along, who are mostly white males, feel somewhat, challenged by the fact that maybe they won't succeed as much if they let more people in of all different varieties. So that's very, very real. And the other perspective is sort of my own history in all of this. I graduated from law school in 1981, and shortly after I was admitted, I joined the Women's Bar Association, and not too long after that, there were sort of a handful of us that were trying to promote among the local politicians the idea of making women or allowing women to enter the process of becoming judges in this area. Now, when I was appointed to Albany City Court in 1997, I was the second female Albany City Court judge ever. When I was elected to the Supreme Court in the 3rd Judicial District, I was the 3rd female ever to be elected to that position in the 3rd Judicial District. In 2008, now we're getting closer and closer to where we are now, I was still the 3rd female appellate division judge in the 3rd department. And that included one woman from Buffalo who was appointed to that court. She was actually the first, which is not in the 3rd Judicial District. And then in 2015, 5 years ago, things are a little bit better, but still, I am the 7th female ever to be appointed or elected to New York's highest court, the Court of Appeals. So going back to that beginning in the early 1980s, when a group of us would approach the politicians and say, we have a lot of qualified women for these positions who are interested and they want to be active, and they looked at us like we had 6 heads. They really did. And all they wanted to know is, well, have you been a committee person in the ward where you live? Which of course we weren't accepted in those positions, even if we wanted to be. And there was one excuse after another. And it really, it's somewhat like the efforts to get women the right to vote, efforts to get women the right to even be available for judicial positions have been very slow, and there's still a lot of barriers to that. And one other just little story I want to bring into this, because I think it is emblematic of a lot of things. When I ran for Supreme Court in 2001, the 3rd Judicial District consists of 7 counties, and the geographical area is about the size of the state of Connecticut. So it is, and these 7 counties are all very, very different counties. And so it's really quite an effort. So I had a whole team of people helping me in my bid to be elected. And of course, fundraising was part of that process. And my spouse got very involved in the fundraising, and he thought, well, this will be easy because you have been involved in so many women's groups, and all we'll have to do is reach out to the women and we'll get lots of donations. And he was appalled at how little money came from women to support a woman candidate. And that's something that I've never forgotten, because the power of the purse is a real big one. So all of this sort of coalesces together, progressing in the profession, progressing in business, progressing in politics, everything, and really becoming a force. So I guess I would sum up with we've made some progress, but there's still a long road ahead of us.
From Judge Stein's impressive history, I too ran the same Supreme Court race, but 14 years later, and I was the first and still the only Black person to win or even be the candidate, not only in the 3rd Judicial District, which is 7 counties, but in the 3rd Department, which is 28 counties. So progress has been made, and I'm grateful that I was elected, but I think it shows that there's still a lot of room for growth.
So we got to change our culture, because our law firms, our courts, we have to change our families. We have to change our gender and expectations. We have to change how we segregate ourselves based on what we think and how we identify ourselves. So where do I see hope? I see hope in social science. I feel that we're now able to name what we all couldn't name before. There's a 2018 ABA report coming out with systemic bias in the legal profession, which is both on gender and race. And what's really interesting about the reports you see now, in the early days of these reports, it was sort of, well, we all kind of know, but we don't know what to call that. What do we call that when it keeps happening and oppressing us? And we can be dismissed that, oh, you're too sensitive, you're oversensitive, oh, maybe that would happen. Well, now we have all these social scientists that have been consistently doing research that shows that white men are based on their potential, their promise, right? Like, what are they? There's this characterization, and it could be about how people look at children and say, oh, this person is the athletic person, or this person is this, and based on gender or race. So some of the social science that I think can really help us name it and be unabashed about claiming it as what we want to get rid of culturally. So one is prove it again bias. So over and over, when you have these social science studies where they'll show resumes, right? And they'll show that the 2 equal resumes, they change around the gender name, or they change around something that indicates the race. And the white male has great promise, scores much higher objectively, whereas on the same things they've already done. So the prove it again bias is that for women and people of color, you don't have to just do it once. You don't now suddenly have this great, brilliant potential. You have to do it again and again. And some folks who were raised either as children of color, or maybe with parents who said, it's okay, you're going to have to do a little bit more because you deserve to get ahead. Well, it's not okay. They didn't mean that. What they meant is, yeah, this is the way the world is right now. Another social science is the tightrope you have to walk. I think it's really interesting that whether it's Amy Coney Barrett or Kamala Harris, we had to show Kamala's mamala side, because the myth of motherhood is really something that has almost been made up by misogynists to be so impossible that if you're a single person, well, you're not a mother, right? But if you are a mother, there's so much to get attacked on. Like, you have to show your mom, I'm a good aunt, I'm a good this. So that myth of motherhood and what it means is a cultural thing. It has nothing to do with raising healthy children. It is a gender, like, it's almost the cowboy and the mother is sort of someplace in American psyche. But we can do better than this. I mean, we have our Mae West. We have other icons that we can search for. So the tightrope is another thing, the bias in terms of that. The maternal wall is another social science issue. The tug of war, or the oppression Olympics, talks about, we took that Irish American girl for that. So, maybe we don't have to take the lesbian something else, like almost like there's a limited pool when it comes to different characteristics. So these are the social science things. They can be implicit bias. We now know enough that we can work against bias. You can do it. It takes work. It takes conscientiousness and mindfulness. It's kind of like Alcohol's Anonymous. If you don't admit you have a drinking problem, you're not getting over it.
Okay. Would anyone else like to add?
Yeah, could I? So, this is very much along the lines of what Professor Lynch is talking about, because I think when you look at, and just as Judge Stein and Judge Riba said, the numbers are quite terrible, that in our profession, the number of people who become law firm associates is close to being equal in terms of gender, but by the time you reach partner nationally, this is from 3 years ago, so it may be better or worse. 19% of equity partners are women, and women are 29% less likely to reach the first level of partnership than men. And the numbers are even worse for women of color, who experience the steepest decline in representation as attorneys' careers advance. 16% at entry level, but only 10% senior associates, 3% equity partners. So the situation is terrible. Our profession is failing terribly at equality, and we can't blame it on the rest of society, because the numbers in law school are not disproportionate. The numbers at entry level in the firms are not disproportionate. I think society has a lot to do with it. I'm not saying we shouldn't blame society at all, but our profession is much worse than it should be and that it can be. And I think that the reasons why, as Professor Lynch said, it has everything to do with norms and expectations that social science can help illustrate. I want to illustrate it just a little bit with personal experience. So, as many of you know, I came out as transgender in February. I'm about 2 years into a gender transition that will probably take another 2 years at least before it reaches sort of the point in the gender spectrum that I'm going to be aiming at. There was a story in Greek mythology that Tiresias, the prophet, had special insight into gender because he had spent 7 years as a woman. I've only been out as trans for about 6 months, so I don't have the full Tiresias insight. And probably a lot of what I've noticed is sort of old news to many of the people who've gone through much more years as a woman than I have. One of trans people's least favorite thing to hear, by the way, is "welcome to being a woman." Like, we didn't choose this. It was not a pros and cons analysis, I swear. But I think that before I transitioned, I was vaguely aware, but not personally conscious, of how many more hours in a day it takes just to be a woman compared to being a man. The preparation that's expected to look professional. It takes hours and hours more each week to look professional as a woman than it does to look, quote, professional as a man. I can't roll out of bed with this hair, even though it's not yet the way I want it to look. And so I go to a workshop at St. Rose for trans women in transition that teaches us how to modify our voice and our physical posture and bearing in the world. And when we talk about physical bearing, they teach us ways to be smaller. Mm-hmm. They teach us ways to take up less space. Keep your elbows in. When you laugh, laugh up and in instead of forward and out. When you gesture with your wrists, not from the shoulders. There's even a running joke about how men shout when they sneeze, which is really true. And I have no idea why that is. There are men who sneeze like, "I rush you," like it's a wolf howl, right? But if you want to be perceived as feminine, you learn to sneeze like this, chew. And if you think about our society's measure, what we try to teach our students as law students, right? There's a well-known book called Becoming Gentlemen by Lainey Guinier and colleagues. And that's, in many ways, the paradigm of the successful lawyer, which overlaps with ideas like confidence and ambition, and also, no doubt, with commitments that are reflected in time and not being interested in spending time with family. And as many feminists have pointed out, I think the answer needs not to be recruit more women who are willing to make themselves fit the male paradigm that we've developed, but change the paradigm. It'll be easier to change our profession's paradigm for what confidence looks like than it will be to change society's paradigm for what women should look like. But it'll still be very difficult. And I think, certainly in law school and as role models like the judges here, thinking carefully about the norms that we model and the ways that we comply or don't comply with those expectations and encourage our students to do so is a nightmare. And it's an ongoing nightmare that we have a responsibility to never wake up from. And I'm sorry if that sounds a bit pessimistic, but like I said, I didn't choose this transition, and I'm not sure it's a good deal. But I know we'll make it better. I'll try to say something positive at the end there. How about that?
Thank you, Professor Ayers. I have a question. It's not on the list, so please feel free not to answer this question at all. But this is just purely from personal experience. I know every woman that I know has a story, has some story about sexism or misogyny that they have experienced in their legal careers. And I was just wondering if any of you have a story that you wouldn't mind sharing. You don't have to name names, but any of you, because we have a lot of students, and I know that sometimes we talk in a way where we don't give enough gravity and honesty as to what they might experience as students. So any stories that you might like to share?
How long do you have, Christina? So I guess I would just summarize that I have a lot of stories. I sometimes choose to remember them, and I sometimes choose to let them have no power in my life. Mm-hmm. The stories include expert doctors who I'm trying to prep, touching me inappropriately. Court officers doing that. They include when I do something brilliant, when I was a young ADA and we were trying to keep a cop who used his off-duty gun, we went up to the appellate division, which, and I had been in the appeals bureau first, and I did because I knew it was going to work, I did I'm sure, as you're well aware, there has to be a preserved objection in order for there to be no bail increased and the defendant to be remanded while appeal is pending. And I know that you know that, Your Honor. I'm just wondering, because I would love to figure out, I'm so ignorant that I need to know what the preserved objection is. And of course that worked. And guess what? The guy was remanded, and the senior person, who actually was a really rigor, said, "Do you realize what you just did?" And I basically said, "No, what did I do?" Oh, and so I think there have been so many of that underestimation, that sense that you know exactly what you're doing it strategically, and it's perceived not as strategy, but or brilliance, but it is perceived as somehow this innocent, mistaken tripping into the right thing to do. So I choose to not dwell on those stories. My sister says I have this great ability to forget the bad stuff. And I think sometimes it is important to learn from them. But I think that what I'm most concerned about with the students is that I feel that your generation has grown up with more myths around femininity and gender and motherhood than I did in the 70s. And I really worry about your ability to balance all of that. So I am grateful that I grew up in a more liberating time.
Well, it's interesting, because my fear is that the female lawyers of today, particularly law students, because you go to law school and you see that that the numbers there are at least equal, men and women. And my fear is that you will be complacent about it and not and not vigorously seeking to eliminate the bias that there is and that there still is. And it may be less obvious at times, but I don't know, but when I was starting to practice law, there were no women judges. And so when I went to a conference or a trial or anything in front of a judge, they didn't quite know what to do with me. And so maybe they made inappropriate statements. Maybe, I was in a room and there was a male attorney or several male attorneys, and they would all be talking about the good old days when they went to high school together, or some sports that they just assumed that I don't know anything about, and they were probably right. And things like that, to really inappropriate sexual statements or statements about my appearance. I had one judge when they had just come out with the Committee on Women in the Law in the 1980s, came out with a big study about women in the law and how and how there was all this gender bias, and it was kind of new at that point. And one of the judges before whom I regularly appeared asked me into his chambers to discuss this report and asked me if I wanted to sit in his lap while we talked about it. I mean, so hopefully that kind of thing doesn't occur, because there are a lot fewer people out there that think that that's funny or appropriate or whatever. But in less explicit or obvious ways, it still exists. And sometimes if you're not paying attention, you might not catch it, but it's still there.
Thank you. Okay, let's move on a little bit. I want to talk about the Equal Rights Amendment. And my question, and this is for anyone who would like to answer, do you think the Equal Rights Amendment would be supported by the suffrage movement? I know that was a tough one.
Depends on, there is no one suffrage movement, right? I mean, if you think about, I think the one thing that in the United States we forget is that we only achieved suffrage because of the violence that occurred in England. I mean, I truly believe that historically, I mean, we know there was violence here. We know there were women imprisoned. We know that, but and I think that the actual, when you talk to legislation or even constitutional amendment, those are all sausages. Those are all compromises made, right? That what do you give up? Where do you go? It's kind of, in some ways, it's like the stimulus money. So I think I don't want to essentialize any particular suffragist. I sort of feel like, do I think Kate Stoneman would? Do I think Ida B. Wells would? I think that the movement had different leaders at different times, as many movements do. And so I think that makes it a really hard, and I think some people would absolutely not. Some people, it was just about the vote. It wasn't about a different definition of equality. It was very Victorian, actually.
I think I agree with Professor Lynch. I mean, obviously from the history, we know that there were many suffragists that were not in favor of equal rights for everyone, because they wanted to get what the end result was, which was the right to vote for white women. I think it started out for all women, but they realized that wasn't going to work. And so sometimes you have to focus on taking those steps to get to the ultimate end result, which is, 1965, when we now have the rights for Black women. But it was one stepping stone. It can't take away from the fact that that was progress, not for everyone, but there was progress. And I think for me, I'm always looking at the positive side of things, the glass is half full, because I think without looking towards the future and having optimism, then there's no hope. So I think that the answer is, it depends on who the person was. Like Ida B. Wells, obviously, she was going to be somebody who focused on equality. Susan B. Anthony, not so much. So I think the answer is yes and no.
And I think the bigger question is why 100 years after women got the right to vote, is the ERA still so controversial? You know, what is that about?
Well, and I think that what you're focusing on is there was an article in Ms. Magazine that Professor Clark sent around onto the faculty political discussion. And it was an interesting article, and the name of the article was Abortion Was Never About Fetuses, it was about motherhood, right? And so whatever your position is on the abortion issue, what's more interesting about this question is that when does equal rights mean that, you know, what is sameness and what is equalness? And I always say that this reminds me of being a parent. And you say to your child, I am treating you equally. I am not treating you the same. This one is only 3 feet high. This unit is this age, right? This one is this is this. Being treated equally, right, is a judgment of.
Oh, Professor Lynch, you're muted.
Oh my God, I'm going on and on. So being treated equally is different than being treated the same. And I think the dialogue around the ERA, and I was saying it reminds me of parenthood, when, you know, oh, you're not treating me, you know, you're treating differently, you know. Yeah, stop whining. Being treated equally does not mean the same. Saying a pregnant woman is allowed to have a chair that accommodates her belly when she's at work is not discriminating against the non-pregnant employee. Right? So I think this equal and sameness argument is, I think, fear-mongering, and I think also an indication of how we accrue social structure of what it means. It's much more about what it means to be a male than it is about what it means to be female, or to be a woman, or to be presenting as a woman.
Okay, let's pivot a little bit here. And this question is for the professors. Don't worry, judges, you guys are up right after this. So you're not completely off the hot seat. All right, so for Professors Ayers and Lynch, according to the ABA in 2019, there were a record number of women in elective office. Do you think this is a result of the 19th Amendment?
Okay, I guess I'll try that one. So the question about the number of people in elective office, if it is a result of the 19th Amendment, it's very disappointing because the numbers are terrible. I mean, the progress is great. The progress is fantastic, but the numbers are terrible. So nationally in 2020, 23.7% of seats in Congress and 26% in the Senate. Statewide elective offices, 28.9. State legislatures, 29.3 or 30.3. Municipal officials, among the 100 largest cities, 27 had women mayors. These numbers are a national embarrassment. And so, to say, did the 19th Amendment contribute to them? Well, maybe, that's possible. I think that there are really interesting empirical questions about whether voting plays the role that people hope it does, which is to bring about more equality. Right? The theory is that elected officials, if you have the power to vote, will care more about you and will act more in your interests. And that makes sense in the abstract, but our democracy doesn't always work out the way it's planned to on paper. And so there are a lot of things that interfere with that idea. I think that I completely agree. It's very strange that there are controversies about the Equal Rights Amendment. It's very difficult. As somebody who's not studied that thoroughly, maybe I'd be able to get more insight into that. But it's very weird. Like it kind of just says women should be equal, and that's all anybody ever admits to believing out loud. So I think there's often a disjunct between the theory and the reality. And in terms of representation in government, again, I think that the norms that Professor Lynch talked about are still a substantial obstacle. If you think about the use of the word ambition as it's applied to political candidates, it's very difficult to imagine something stranger than criticizing a political candidate for ambition. They are literally asking people to go into a booth and say that they like me so that I will get more power. I can't imagine anything that's closer to the definition of ambition. It's in the job description. But I was at the dentist today and I saw a political ad that attacks a candidate, and it's black and white and it's scary music and it's unflattering pictures and it's "she chose ambition" is the line in the ad. Well, of course she's running for office. I hope so. Wouldn't it be weird if she chose, humility and modesty? My opponent is better. There was a political ad once in Indonesia that said, "I don't know whether I'll do a good job, but I'll try." Right, which is really great, but it's not exactly the norm or how you advance to power in US politics. And so I think that along with norms about ambition, norms about what leadership looks like and what leadership means, I'm very proud of my colleagues at the law school who have started this women's leadership project, because I think that changing ideas about leadership in the profession is crucial. And as the director of the Government Law Center, obviously there's a lot more to it than social norms. There are also social networks and who is connected to who, and who goes golfing with who. If sports is any indication of gender status, I should have realized I was transgender a lot earlier by my utter lack of interest in anything that involves moving a ball from one side of a rectangle to the other. But I think, which would have disqualified me had I sought to network my way up into various corners of the legal profession and the world of government. And I don't think that's the kind of thing that the 19th Amendment was successful in changing. I think women have the vote, but equality is something very different.
So what she said, and let's face it, what's important about the 19th Amendment is not just its words. It's not just, it was momentous, it was a moment. The reason it was only a moment is because what was more important is the spirit that you can find back in our country very early on. I was just Googling and picking up one of my favorite books by Sue Monk Kidd is called The Invention of Wings. And it's about the Grimke sisters who were abolitionists and feminists, but a long time ago. Sarah was born in 1792. And it's the spirit of saying, our country isn't done yet. This isn't fair. We can make it better. And that's what the 19th Amendment was. The 19th Amendment was, maybe there's a way that together, through law and society, there were, at the Declaration of Sentiments in Western New York, and if any of you have not been there, when COVID is over, we're going to do a great alumni and ever trip again. Kate Stoneman was inducted into the National Women's Hall of Fame there. But there were men and women who said, this is making our country worse. This makes no sense. So I think that's the spirit. If you're talking about the spirit of part of the history of the 19th Amendment, not the part that betrayed people, but the spirit that said, this is important. We can make it better. Did they know? It didn't do what they said initially it was going to do. It didn't. There were betrayals along the way, but there still was a spirit of saying, maybe we can make it better. And I think that's the spirit that we still have today. And that's certainly the spirit I see in the Justice Center with folks who are, and with our experience base, and with our student activities, and with our pro bono program that, and with marches, and with all the ways that we say, no, we see something and we say something. So in that way, So in that way, I'm one of those people who didn't learn to just do her wrists. So I'm like hitting everything with my 2 laptops. And So in that way, I think, yes, it is, it clearly was that when you put toxic masculinity on patrol, people finally go, oh, we should do something about this. But I think it also was the spirit that led to the changes in law, the amendment to the Constitution. That spirit, I think, was carried forward.
Thank you. And now I get to cold call the judges. Never thought I'd be able to say that. As we discuss voting rights, as state judges, do you have a role in the election process? And if so, what is it?
So the New York State Supreme Court is where challenges in election matters are commenced. Most election matters are started by filing and serving an order to show cause, which requires the parties to appear before a judge on a specific day. And decisions are typically issued within a day or two of the hearing. If the losing party is so inclined, they can appeal the decision to the appropriate appellate division. And in Supreme Court, one judge hears the matter, makes the decision. At the appellate division, there's a 5-judge panel which hears the matter and renders a written opinion as expeditiously as possible. The last level of appeal within the state system is the Court of Appeals, which is the court of last resort. And there is a formal procedure whereby parties ask permission to bring an appeal. Election law has very specific statute of limitations, which must be complied with. For example, to grieve primary results, the aggrieved candidate must commence the action within 10 days of the primary. There are also strict service requirements. Election law and the CPLR must be complied with if the candidate would like the court to address the merits. So to that end, as a Supreme Court justice, I hear cases to remove candidates from a ballot. I hear cases challenging the number of petitions, and the list goes on. At the hearings, the parties call witnesses in attempts to establish why certain petitions are valid and why they aren't. In this process, the court reviews the admissible evidence, listens to the testimony, and based on those factors, I make a decision. This process is governed by New York State election law. Overall, the court will lean towards the most open and fair process such that a candidate is allowed on the ballot unless it's clear that they have not met their obligations. As a Supreme Court judge, I also serve on call to make determinations on election day or primary day to allow a voter to cast a vote or cast a provisional ballot when their right to vote is in question. And this year is especially interesting due to changes made to election law by executive orders to address COVID-19. For example, there were executive orders that moved the presidential primary from April 28th to June 23rd. And another change based on COVID-19 was the section of election law was temporarily suspended and modified to provide that due to COVID-19, an absentee ballot could be granted based on temporary illness and the potential for contraction of the COVID-19 virus for any election held on or before June 23rd. And so after an election, the court may be involved as well when there are challenges to the vote counts brought by candidates. And I believe the State Board of Elections convenes in December to certify the state level and federal races. None of these races are settled until that, regardless of what you may read in the newspaper. And as a Supreme Court judge, I too am elected. And as an elected official, I understand personally how the election process can be impacted by people in power. Nonetheless, I'm still the first and only Black nominated candidate to win in Supreme Court. And my role in Supreme Court has a limited review. For example, if lies are told about a candidate on the eve of trial or on the eve of an election, there really is no recourse. So according to election law, the court is limited to reviewing whether petitions are valid and whether those votes are properly tabulated. So if there are lies told on social media, that is not an election matter. Perhaps down the road, the candidate would have a defamation case, but that would not save the election results. So the court's job is to make sure that registered voters utilize their right to vote and candidates have the opportunity to run for office if they meet the criteria. If the election's tampered with from foreign actors or from local people in powerful positions, unless it comes down to a campaign finance issue, there's really nothing the court can do to fix bad information in the confines of election law. So we have limited review, but I take my role very seriously, and this year is particularly interesting. There's early voting. I'm on call for early voting. I'm also on call on election day.
So I absolutely agree that election law is a very unique area of law for a lot of reasons. One of them really is the whole timing aspect of it, and how little time there is to get into court to see Judge Riva in the first place. And from there, if you're not satisfied with the result, to get to the appellate division, and from there to get to the Court of Appeals, all within the time for filings, and then the time when it gets, well, it's true for all of us, but when it gets to the Court of Appeals, the question is, can we make a decision that will make a meaningful difference? One of the questions is, can we make a decision that will make a meaningful difference before they have to go print the ballots? And ultimately the question is whether one candidate or another is entitled to be on the ballot. And the election law statutes are required to be construed and interpreted strictly, and there, and of course, we don't hear witnesses. Everything we do is based on the record that was produced in the Supreme Court before Judge Ryba, and then on her decision, and then the decision of the appellate division after that. And our role is to determine whether there has been an error of law. We don't go back and look at the ballots. You know, we take what has been done by the other courts and we say, given these facts, because in the Court of Appeals, believe it or not, we do not have the power or the jurisdiction to decide facts. We can only decide questions of law. And you know, that's a whole area of law in and of itself. What is a question of law? For example, if an argument isn't made in the trial court, then that argument is not preserved, and that means it is not a question of law. So we are in a very, very short period of time, and actually the way we work it at the Court of Appeals is that we set a day for arguments. The lawyers, and many times there are no lawyers, it's the candidates themselves. They submit in writing their arguments and why they think that the Court of Appeals should hear their case, because we're a certiorari court for the most part, like the United States Supreme Court. We choose, there are certain cases that get to be heard as of right if there's a constitutional question and it's directly involved. For example, if there's a 3-2 split in the appellate division in a civil case, then you may have the right. But for the most part, we choose the cases. So the litigants or the lawyers have to make their argument as to why the case that they want to bring has statewide impact and is a question of law that requires our attention at this time. And then what happens is they come in, they get a few minutes to argue in front of a panel of 3 of us, as two or three, as to whether we should even take their appeal. And then that's all done in the morning. And then we let them know as soon as we're done, usually around midday, whether we're going to take their appeal or not. And if we do, then they have to argue it that very same day. And then we usually make a decision that day or within the next couple of days. So it's in some ways it's a limited role. Our role is more limited than Judge Riva's role is, but in other ways, the cases that do get heard on the merits before us are usually cases with statewide impact, and the decisions are made to clarify what the election law means in a particular circumstance.
Thank you. I want to make sure we get to some student questions right now. And this is actually directly on point. We have a question from Ruchi who says, there's a guideline in India where no voter should be more than 2 kilometers away from a polling station. She was wondering, why do you think we can't do something like that here?
Yes, please. Professor Dodds, can you repeat the question again?
Okay, sorry. Rishi says that there is in India, there's a rule that no one should be more than 2 kilometers away from a polling station. And she was wondering, why can't we have something or do something like that here?
We do have rules that people can't campaign a certain distance from the polls. And if they do, the sheriff's department is called and they're removed, because you're not supposed to, according to election law, there's parameters that must be followed with regard to campaigning close to the actual voting site. So is that the question, or is there?
No, I think I know the I think the question is really, why is it that we don't have a rule? So I was talking earlier about geographical suppression, right? That basically there are places that it's really hard to get to the polling place, or there are other forms of suppression. Okay, this is not my legal view, because this is not a legal question, right? We don't have laws that do that. So my opinion as to why we don't is part of why folks want to get rid of the two-party system. Right now, voter suppression helps Democrats, though hurts Democrats, right? Voter suppression helps Republicans on the national stage. And so having a law that does that, one might want to think that politically folks would want it all to be fair. But the reality is that that has become a political question in which it is outcome driven by the, who would get more votes or less votes based on that. In preparation for tonight's event, I talked to my son, who worked for the League of Conservation Voters on their voting rights project and is now working for the Vera Institute of Justice with people with disabilities and voting rights. And so I was checking with him that my opinion was founded on research that had been done. And so, and he was very careful about it. I mean, our political system, being nice to say that Democrats will do what's fair, not what's going to get them votes, or Republicans will do that. But on the issue of voter suppression, and I do believe there are litmus tests where politicians are not just hired guns for an outcome. I don't believe that they are that. I'm not as cynical as that. But the history of our country right now has come to the point that politically, if you work for Republicans, and there are some moderates who will not agree with it. There's arguments that, Trumpism is not the Republican Party. There's a lot of different opinions on that. But right now, it is outcome driven. And that is why we can't get it done.
Okay.
Just to add one real quick thought, I think that part of the challenge here is that the way US election law is set up, state law presumably governs, or presumptively governs, not presumably, presumptively governs unless a federal law is created that overrides that. And so in Georgia, so we're seeing closures of polling places nationwide, election by election. In Georgia, there's a report that 7 counties that cover hundreds of square miles have only 7 polling places. You've got a question of resources, and I think unfortunately, there may be ways, election scholars have proposed various ways to depoliticize the elections process, to have, for example, a national commission whose members are appointed rather than by elected officials appointed by others. From time to time in New York State, people suggest that the judiciary appoint people to various commissions or oversight bodies rather than having them appointed by elected officials. Although of course many judges are elected. And so I think that one of the most important questions in voting reform is who should be making these rules, because right now it's definitely true that they're not always serving the purpose they should be.
Yeah, and I think the simple answer is there is no reason why we couldn't do it. I think the more complicated answer is, are the political obstacles and the practical obstacles in terms of, particularly today, because of COVID, just getting enough people to be poll watchers or people to run the, be at the polls to run the voting mechanism is a challenge. So yeah, I think there's a lot of reasons, but it's something that we could certainly hope to be able to achieve in the future.
Thank you. Unfortunately, we're out of time, so I'm going to turn it over to our closer. This has been an awesome conversation. Thank you, guys. Wonderful job. Okay, in closing.
Thank you for our awesome moderator.
Thank you, Professor Dodds. Thank you.
Hi, everyone. I'm Kelly Amorum. I'm one of the co-chairs of the Women's Law Caucus, and I'm a secretary for ACS. And on behalf of all of us, we want to thank our panelists, Judge Stein, Judge Riva, Professor Lynch, and Professor Ayers for your time and your insightful comments. We would also like to thank Professor Dodds for being our wonderful moderator this evening. She did a fantastic job. And I would also like to thank Alicia, who's the co-chair of Women's Law Caucus and co-chair of ACS, Harris, who's the co-chair of ACS, Aaron and Nick from the Government Law Society, and to all of our e-boards for all of your hard work in planning this event. This is going to be a shameless plug, but ACS is co-hosting an election watch party with the Albany Law Democrats. And next week, WLC is collaborating with the Albany Law Literary Circle to discuss a piece written by Kiara Bridges titled "The Nerve: Women of Color in the Legal Academy." There will be emails coming for all of these events. Once again, we want to thank everyone for coming and taking time out of your night to come to this panel. So thank you for joining us.
Thank you for arranging this. It was a terrific thing.
And I just love the synergy and collaboration of the different groups coming together, because I think that is actually, that's what's going to happen. Constance Baker Motley said eternal vigilance and coming together and working together. So good job. And how prescient to put it on a night that we're actually having a presidential debate, as opposed, right? You guys were so wise.
Everyone take a shot.
Good night, everyone. Thank you.
Good night.
Good night.
Good night, everyone.
Good night. And you didn't have
Ciji,
to.
I'm glad you didn't turn my mic off.
Never that merry.
Good night, everyone. Take care.
Good night. Have a nice
Bye. Thank you, Judge. Thank you, everybody.